welcome. This is the law. It is your legal light. It is your help law. This is your educative law program where we try to help you as best as we can. And we're continuing part 2. You called and beyond here made calls to us to ensure that we have part 2 of the discussion we had last week. And so we are very grateful to His Lordship Alexander Osei-Tutu for making time out of his very precious schedule to join us today. So welcome to the law. We are continuing with our series, Essential Themes on Land Law.
Section 11 of Land Act 2020, Act 1036, Prohibition of Discriminatory Practice. A decision or practice in respect of land under customary tenure, whether the land is individually or communally held, shall be in accordance with the customs and practices of the community concerned, but a decision or practice which discriminates on grounds of A, place of origin, ethnic origin, political opinions, color, gender, or creed, B, disability, or C, social or economic status, is void.
And that was the Law 101. And today we are looking at Section 11 of the Land Act, and it is headed Prohibition of Discriminatory Practice. And as you just read a while ago, a decision or practice in respect of land under customary tenure, whether the land is individually or customarily held, shall be in accordance with the customs and practices of the community concerned, but a decision or practice which discriminates on grounds of place of origin, ethnic origin, political opinions, color, gender, or creed, disability, or social or economic status is void. My Lord, what does this mean?
Thank you, Samson. This means that upon the enactment of the Land Act, be it an individual land or a communal land, the holder is not supposed to discriminate in respect of the grantees, whether the person is coming from the northern part, the southern part, the eastern part of Ghana, in respect of political opinion. It is immaterial which political party a person belongs to. Any attempt to discriminate on these grounds, the law tends to prohibit it.
We say that the law always is intended to cure a mischief. Sometimes, maybe. So what is the mischief that is being sought to be cured by making a law that says that you cannot say that you won't give land to a person because of his origin, because of his ethnic origin, because of his political opinions, because of the person's gender, be a woman or man, or the person is disabled, economic or social status? Why will you make such a law?
You know, we are in the 21st century. An attempt is being made by all countries to ensure that prohibitions in any form is avoided. So I believe, looking at the direction of states, the lawmakers felt that it is necessary to introduce into our laws such a provision so that there wouldn't be any attempt to discriminate anybody on grounds of sex, ethnic origin, political color, gender, occupation, religion, or creed. And what I thought, in my personal view, the lawmaker could have added was to more or less criminalize it. Because if you say a decision, not the grant itself, just a decision or practice, it's quite vague. So a distinction can be drawn between the taking a decision and a grant. So I thought the lawmaker could have gone further to extend the scope to cover grants.
It says a decision or practice.
Practice.
Which discriminates on grounds of.
Yes.
So
it's quite vague in my view.
Right. So where I come from in the Upper East region, you would see that often it is not women who have the opportunity to own land. And I think other places too, we have heard the stories where women who need land must get a man to help them to get it because the land will not be given to them as a woman.
Yes, we need to be careful with this provision because let's read carefully. It says a decision or practice in respect of land under customary tenure, whether the land is individually or communally held, shall be in accordance with the customs, traditions, and practices of the community. So it does not completely take it out of the purview of the community's practices. So shall be in. So it takes us back to the colonial times. Colonial times when the white man decided to sieve our laws and felt that laws which were inconsistent with natural justice should not be, were deemed to be repugnant. Yes. It takes us back to that era.
So what he's saying is that even though you will deal with the land in the manner in which your custom or your traditional practices agree with, there's an exception that has been made.
Exactly.
You can do anything except discriminate on the person's ethnic origin, political opinions, disability, gender, social and economic status.
Yes, that is what the law seeks to do. But if you read the law thoroughly, there's some form of discrimination even in the law itself. For example, under Section 5, it deals with usufructory interest. Now, if you live in a community for a very long time, that's 50 years. After 50 years, you qualify to be treated more or less as a landowner, which we call usufruct. Before the enactment of Act 1036, it was only the indigents who were recognized. But now, anybody who is able to live at a place, unless there was an express agreement that you settle here for, let's say, 30 years, 20 years. If there's no agreement and you live at a place for 50 years, the law automatically confers on you the power of usufruct to enable you even alienate or transfer the property to your descendants. And you go further, the law says, so we have two categories of indigents, usufructs, indigent usufruct and non-indigent usufruct. But you read further, the law says that for those who do not come from the area, if they want to transfer, they need the consent of the community. So this is a form of discrimination. The law itself has some discrimination. Why is it that after recognizing the usufruct, the indigent, the non-indigent, you turn around to say, in his case, before he can transfer his land, he needs the consent of the Allodia owner.
All right. And when you hear my Lord use alienate, simply means give out. In the very simple terms, that's how I can explain it. My Lord, in the course of this week, something happened that got many people talking. And a good friend of mine, Ace Nkuma, had to write. on social media to try to educate people about something. And it is something that you educated us about last week. So a group decided to issue a list making these demands on somebody who had gotten a land in Accra. And here are the demands. They required 1 big ram, 2 white fowls, 1 crate of white eggs, 2 bottles of Castle Bridge, 1 bottle of whiskey, half piece of white calico, and an amount of 30,000 Ghana cedis. And they concluded in that demand notice with these words, that after which the client is assigned contractor or contractors. The client's assigned contractors can continue the peaceful development on the parcel of land without any hindrance or disturbance. Any person or group of people demanding such customary right should be referred to us. Thank you. So these are the demands they made, and they are saying that if the one who has procured the land doesn't give them all of these, including 30,000 Ghana cedis, his or her assigned contractors cannot continue the development of the land, or at least they cannot do so peacefully without any hindrance or disturbance. I want you to take us back and help us to appreciate what our rights are as landowners once we acquire land, whether this is lawful, and what we can do to get these people at bay.
Thank you, Samson. Last week, like I did say, there are several interests that one can acquire in a land.
That's right.
And I touch on Allodia interest. And beyond the Allodia interest, we have other interests like assignment. So if somebody acquires a lease, I acquire a lease for 99 years.
Right.
What I can grant is an assignment.
Right.
Assignment means along the line, let's say I stay on the land for about 40 years, and you express interest in acquiring the land. It's left with 59 years.
Okay.
I alienate all my interest in the land to you. I can also grant you a sublease.
All right.
Where if it's left with 59 years, I say, okay, stay on the land for about 20 years. Yes. And all this, the law has what we call some rights attached to them.
Okay.
They are implied. And one of the implied covenants which the law provide, what I mean by imply is whether the parties stated it or not.
Okay.
The law says even if the parties did not mention it, the law automatically inserts it in the agreement.
Okay.
That is implied term. And one of them is the grantee. The grantor is supposed to give the grantee quiet enjoyment of the land. Okay. That means that for the period that the person will be on the land, you will not disturb him. You will not disturb his occupation on the land. So in this context, after alienating the land to a grantee, I do not see the authority that the grantor has to turn around to say, I'm demanding this and that from you.
That's right.
In my view, it is illegal.
So, my lord, these are normally the people that we have identified as ASAFO groups, particularly in Accra, where they come and they say you must pay digging fee, which you spoke about. Yeah. So they make all these demands, and now they add money. And they say, until you give us this, you cannot break the land, or your contractors will not be allowed to develop. If you try it, you see the things they will do to you. And to be frank, I have suffered it once.
Sorry about that. And now, like I did indicate, you can go to court and get a restraining order,
right,
which is different from the normal interlocutory injunction. Restraining order, stopping them from coming on the land, and you continue with your development.
So it's either you are doing that, going to court, asking for a restraining order to stop these people because they don't have a right to say that unless you give them all of these things, you cannot develop the land peacefully. And as my lord has explained, you have a certain right that you are supposed to enjoy. and it is called peaceful enjoyment. You have to stay on the land peacefully once it has been given to you by whoever gave it to you. And so any attempt to disturb your peaceful enjoyment of the property is protected by law. So either you go to court and ask for a restraining order. And last week, my Lord explained that the thing is that in our system, before you can issue an injunction, you must have filed a writ in the court, or you must have filed an originating process in the court. But this one has short-circuited the process. You don't need to have filed anything. You just go straight and you say, somebody is disturbing me on the land. First of all, he's not an owner of the land. Even I can't even identify him by name and so on. Yet he's trying to disturb me, so they'll be stopped. Apart from seeking the restraining order, what else can the individual do?
The person can further report them to the police.
Right.
It's now criminalized.
Right.
It's a criminal offense. And I think last week we emphasized that it's punishable summarily between 5 to 15 years.
Okay.
Between 5 to 15 years. So you can go to court for the order and at the same time go to the police to lodge
10 to 15 years.
5 to
10 to 15.
10 to 15
10
years.
to 15 years. And there's no option.
There's no option
of a fine.
Yes.
Okay. That is important for you to hear, particularly those of you who are in this habit. Particularly in Accra, you note, and also don't entertain them. Don't entertain them at all. They have no right to stop you from developing your piece of land, which you have acquired lawfully. So either you go to court, ask for a restraining order to stop them, or you report them to the police and insist that the police should charge them for court. And if they are found guilty, they are looking to suffer between 10 and 15 years in jail without the option of being asked to pay money and go away, which my Lord emphasized last week. Thank you so very much. And last week, there was this lady who actually stressed the need for this part 2 of the discussion. And she says, he said, thank you so very much. That is Joyce Dankwa. She says, thank you so very much that we have listened to their plea and we are coming to give this second part 2 of the show. So the question that she asked was specific. And she said that what are the number of documents and what are the nature of the documents that I need so that I can say, beyond the indenture that you spoke about the last week, you spoke about a lease or an indenture. Beyond that, what else does one need to confirm their title and be sure that nobody can disturb them?
Thank you. What the law enjoins a grantee to have is the indenture. We call it conveyance.
Right.
But prior to that, there must be what we call investigation of title. You don't just rise up and say, I'm going to buy land. If the person is saying that, oh, my father left us property, maybe the property is for a man and his siblings, and one person wants to dispose of the property, you need to ask the requisite documents, like whether letters of administration has been obtained. The one granting the land to you, does he have the locus or does the law permit him to do that?
Okay.
So all these questions must be asked. If it is acquisition from a stool, you ask yourself whether the stool, the one transferring the document to you, is the occupant of the stool. So every case, every interest has to be looked at on its own situation. we do not have specific. It depends on the type of interest being granted. The law even recognizes oral conveyance. A family or community can say that we are giving you this land without any document. The law recognizes that. But what is important is to find out whether the grant you are acquiring does not have any encumbrance. For instance, under the law now, if you want to acquire land to do poultry, the law says that it can't be more than 25 years.
Okay.
It can't be more than 25 years. These estate developers, if you are acquiring land for residential purposes from a family or a stool, the law does not permit the stool or family to grant land beyond 4 hectares. That's more than 10 acres. These are new provisions introduced by Act 1036. So you need to do your investigation of title to know the nature of the land and the documents that have to be attached to it. We do not have specific.
Okay.
Like you go to Makola market to buy, every product has its price.
Right.
You go to a shop, some products have their manual.
Right.
But if you go to buy tomatoes, you may not get manual.
That's right.
So every case has to be looked at on its own. But at the end of the day, you must be convinced that the interest you are acquiring is unencumbered.
Okay. Unencumbered means what?
That nobody has an interest, a prior interest
On
in
it.
that. For example, you are acquiring land, but that land had already been granted to another person.
Okay.
So if you acquire such a land, we say it is encumbered.
Encumbered.
Somebody has an interest in it.
In it already.
And tomorrow he will come and it will affect your interest.
So you mentioned, for example, that if the person says they are getting the land by some inheritance, you need to check if they have an LA, that's letters of administration, or
probate.
There's a probate. Yes. That is the will that the person left that they have now gone to court and been given the power.
And after the probate has been granted,
right,
the executor has prepared what we call vesting assent. That on this day, the property that was left to you, I vest to you, I hand it to you.
Okay.
So it's not enough to say that, oh, my father left me a property and he's dead, so I'm going for the property.
Right.
The law may not recognize you.
It's not enough for me to show you the will in which my father said, this particular land, I have given it to you, Kofi Menu.
The law says after the will, go to court for the court to grant what we call probate.
Okay.
The court to grant the probate to the executor. After that, the executor, the one who is to stand in and ensure that the estate is administered.
The property is distributed or taken care of.
Yes.
Is the one called the executor.
Yes.
Okay.
We'll have to prepare a document for you called vesting assent.
All right.
So it is from that day that the property will be legally recognized in your name.
All right. So this is pure platinum legal education you are getting. If you walked into a lawyer's chambers, you definitely would pay quite a bit amount of money before you got all of this. And people who will lead you in acquiring land will also definitely deserve their fees once they take you through all this. So Joyce Dankwa, the question you asked last week to my Lord, that was, what are the number of documents, or what documents does one is one required to have to show that they really have title or ownership of the property? The education is that first you must do something called investigation of title. The person you are going to get the land from, be sure that they in fact own the land, or as he says, they have interest in the land. Investigate to see that there's no other person already with some interest on the land already. Because if there's already somebody there and they are giving it to you, they may be doing multiple or double sale to you. And that person who acquired it earlier will come and say that you cannot have it because I got it before you came into the picture. So take note of that. Do investigation of title, and that investigation includes looking at the documents that the person has to see if they actually have title to the property. If they say they come from a certain family and the land belongs to the family, be sure that they in fact come from the family. If it is a stool, do they actually belong, and do they have the consent of the requisite people to be dealing with you? You do all that. So if I do all that and I assure myself that the land is, as you just explained, is unencumbered, and that the person who is giving it to me has the right to do so, what next am I supposed to do? Because the indenture will be done for me. What next am I supposed to do?
Thank you. Let me make this point before I proceed.
All right.
It's in respect of court decisions. Prior to the enactment of Act 1036, if you get a court judgment is also one of the what we call good title.
All right.
If you got a court judgment, all you had to do was to go to the Lands Commission office to register it. But now the law is saying that if you get a court judgment, one, if there is a conflicting court judgment, that court judgment will not be registered by the Lands Commission. A conflicting court judgment, like High Court in Accra has given the land to you, and another High Court in Tema has given the land to another person, where they conflict. But by a court of concurrent jurisdiction, that is High Court, or Circuit Court.
Okay.
As for a superior court, it will, let's say, High Court and later Court of Appeal. That of the Court of Appeal will override that of the High Court.
Is so.
But where it's concurrent, the law says that title, you can get judgment all right, but it will not be recognized. Okay. And also, the law now makes it compulsory that any judgment of a court that is to be registered must go with a site plan, so that the land can clearly be ascertained.
All right.
In time past, people registered judgments without even knowing exactly where the land was situated.
All right.
And it created a lot of problems. So now, if you get a court judgment and you go to court, you go to the Lands Commission without a site plan, they will not register the land for you.
Right.
So coming back to the question, before you do the indenture, you might have done your investigation of title, and one of the steps to take is to go to the Lands Commission to find out whether the land has not been registered in any other person's name. So you conduct what we call a search. So you need...
That's part of the investigation.
Thank you. You need to conduct a search, and it will save you one day.
Right.
If there's a litigation, you bring this search to show that, yes, you did not just move to the land. And after getting the conveyance done, you then go to the lands office to start the process of registration.
Okay.
That one, there's a long process.
For the purpose of a land certificate.
Very well.
Okay.
For the purpose of the land
certificate.
Okay. So you go through the process. There will be publication and all that. It's a long process. I cannot take viewers through.
Please take that very seriously. One of the easiest place to do what my Lord calls the investigation is to do a search. You go to the Lands Commission, and the search, it doesn't cost. It's actually peanuts. Doesn't cost you even 50 cedis to do. You go there, they will do the search for you. They are trying to confirm that the person who says that this land is ours, is the land in fact registered in the name of that stool or skin or family, or has it actually been given to that individual and has it been registered to show? If it is there, it will show that it's been registered and the person trying to give it to you is actually registered in their name or in the name of his family or that stool. In that way, you ensure that you are getting a land that is not encumbered. And that can also be very fast. It doesn't take much time to do. Allodia had given us education about when you are people who are going for estate developers, how much the law says you can't get beyond. And remember when he started, when the law 101, the law 101 spoke about if you discriminate, then that is void. Last week he spoke about void and void ab initio, or even voidable. Void means it doesn't exist at all. What you claim you have does not exist. So make sure that you're not getting something that you'll be told it is void. Thank you very much. This is the law. It is your legal light and it is your help law. And our guest doing the part 2 of this discussion with us, that is essential themes in land law, how to acquire and secure your land, is His Lordship Alexander Osei Tutu. He's a Justice of the High Court in Ghana and in the Gambia. Right. So once we have procured our land certificates, now we can be sure that we are free. Everything is intact.
It is prima facie evidence of ownership.
Okay.
But we did mention conducting a search.
Right.
But the law enjoins the prospective purchaser to conduct 2 forms of searches.
Okay.
One at the law office and another which is an informal search. So you go to the property, you see that there are people in occupation, and you ignore them and go to the lands office to say that, oh, nobody has registered the land.
Okay.
That possession is a strong form of evidence which can affect your title one day. So there are a few instances where the law, though a land might have been registered, the registration can be set aside by the court.
Okay.
Yes. So it is not always the case that immediately you register your land forever and ever, nothing can be done. There are limited instances, like if fraud, there's an underlying fraud or mistake, the court can set aside the registration of your process.
And my Lord had earlier also spoken about judgments. There are certain times that, particularly in Accra, you're going to acquire the land, and how the family or the person will show you that they own it is to show you a judgment of the court that they have been awarded or are judged as the owners of the land. That's why he says, be sure that the judgment that they are showing you is a judgment from maybe at the final stage of the process. If there are 2 judgments, and he has explained that, and all the judgments are coming from courts of what he calls concurrent or coordinate, jurisdiction, like the High Court, one has it from here, one has it from another place, or Circuit Court and so on, then it will not be registered and it may not be the best for you. But if there's another one, someone has one that is from the Court of Appeal, one has one from the High Court, then the one from the Court of Appeal is safe. If there's one from the Supreme Court, then all the better, because that is the final, so to speak. So take note of that when you are doing your investigation of title. They just show you and you say that's okay. Before we
proceed, in respect of judgment, there's this principle which states that a prior purchaser of land is not estopped by a judgment subsequently obtained.
Please explain that.
A prior purchaser of land. Let's say Chief A granted land to me in 1970, and along the line he was destitute or something happened, he's no longer there. We now have a new chief who is sued, or they go to court and the court gives judgment against my grantor. They can't turn around to say that because my grantor has lost the land, I should surrender the land. In other words, a judgment takes prospective effect. So when we are applying the principle of res judicata, res judicata means a judgment of a court binds the parties and their assigns. So if we decide a case today, tomorrow, my grantee or my assign cannot turn around and go to court in respect of the same subject matter. Right. But this principle applies to those who acquire the land from the day of the judgment. So that if I acquire my land before the judgment cannot be backdated to affect my interest I acquired lawfully at the time.
All right. Thank you very much. This is the law. It's your legal light. It's your health law. And I'll take a quick break. When I return, I'm going to be asking my Lord to explain to us something very important that he has explained in his book in chapter 15. He calls it Re-entry and Forfeiture Provisions Reformulated. You will discover that these are circumstances that many people come into in their dealings with matters of, property. So how has it been reformulated? What has changed? And the most important thing you take note of is that he tells us things that have changed in the course of things that have changed by virtue of the new law. This is the law discussing essential themes in land law, how to acquire and secure your land. And our guest is His Lordship Alexander Osei Tutu. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your health law, and our guest doing part 2 of essential themes in land law, how to acquire and secure land, is His Lordship Alexander Osei Tutu, the author of this book, Essential Themes in Land Law and Customary Law, dealing particularly with the new law that has been made about lands. Now, I'll be taking your questions shortly. Some have already started coming in, but let's get him to throw light on what I say is an important aspect that we need to know that he deals with in chapter 15, re-entry and forfeiture. He says that the provisions have been reformulated. What should we know? How does it affect us?
When we say re-entry, it means the right of the original landowner to go for his land. Like Allodia owner grants a land, and along the line, he decides to go back. He decides to take his land back. Like it's common in some communities, the chief will issue allocation paper and say that if you did not develop the land within a year or 2, you lose the land.
Right.
So that is re-entry. And forfeiture is you forfeiting the land. So in literal sense, that is how I'll explain. And the law before the enactment of Act 1036 was not too clear as to the procedure to follow. The law said you needed re-entry could only be done upon a court action or otherwise. And there was confusion in the interpretation, whether the otherwise could mean without going to court, or you automatically have to go to court. But now, the Supreme Court, the law has clarified that, yes, if you want to take back your land, you need to ensure that you give the person notice. You don't just say that, oh, I gave you 2 years, you have not developed the land, so I've given the land to another person. That cannot be done. If the person, there were some terms in the conveyance which the other person, the grantee, has failed to abide by. For example, failing to pay rent. The law enjoins the grantor, the one who granted the land, to write to the grantee, giving him the opportunity to right the wrong. So that if he does not do that, he can then take an action in court. Or if there's any reasonable way to go about it, he takes that step.
That's the re-entry.
Re-entry.
And what triggers the re-entry?
Yes.
How about the forfeiture?
The forfeiture is where the person loses the land. So you re-enter. There's one thing re-entering. You can re-enter unlawfully. Forfeiture, I would say, is where the law, in the eyes of the law finds that no, you are supposed to forfeit your land for not abiding by the terms of the grant.
Okay. So the document you call the conveyance, which is almost like the receipt by which you buy a land.
Yes.
It has terms and conditions.
Okay.
So once you give your land to me, you provide terms and conditions that I am supposed to abide by. If I do not abide by those terms and conditions, including, as you said, paying certain amounts of money that I'm supposed to pay, if I don't do that, then you have the opportunity to re-enter by serving me some notices.
Yes.
Right.
Indicating that I want to re-enter. So if you do not, you must give me the opportunity to do what you claim I had defaulted.
Remedy the situation.
Exactly. So that is the first step.
Okay.
And if it fails, then the court is the first place that comes to mind.
All right.
You go to court to ensure that the court grants you the right to take your land back.
All right. Thank you very much. I have somebody already on the line. Hello, Wisdom.
Yes, good afternoon.
Good afternoon, Wisdom. Let's hear you.
Yes, it's been good. Yeah, last week I called trying to suggest to the program, but unfortunately I think I went off the line. What I want to suggest is, one, I think securing a land actually is a process. So I would suggest that next time when there's a program like this, we can invite a surveyor. I'm saying this because myself, I'm a surveyor. Yes.
I can
a
appreciate
surveyor
that.
should also, either a licensed surveyor or a professional surveyor should also be invited. I'm saying that
Wisdom,
because it's a process.
Wisdom, I have a question for you.
Okay.
You have heard my Lord speak about the investigation of title.
Exactly.
Normally, if a person is going to acquire land and they are using a lawyer or they are using someone who has expertise, they would definitely bring you the surveyors in. Can you tell us briefly what role you play as surveyors to make sure that somebody is not being shortchanged or defrauded?
Okay, the role we will play, as my Lord earlier said, is we will have to go to the first time to get the site plan prepared. And then there are a lot of fictitious surveyors in the system. And we are seeing that as what is causing a lot of the problems on land. Sometimes they go to the site, you see them on site, but the way to even set the machine is a problem. So they will pick, and then you will see them fixing the machine on your plot, as you said. There are so many types of survey. There's a demarcation survey, and then there's a survey that you are doing for the person. If you said the demarcation, what it means is that the person don't know which area to take. The vast land has been shown, so you, the surveyor, have to demarcate it for the person. Or maybe the place is already, the scheme is already prepared by the assembly, so you will go there and then pick the point for the person.
All right.
You understand? But if you are not careful and you are not using the right surveyor, by the time you realize, because the reference is not set well, you take something from Sandema, and then you see the land will be situated somewhere at Navrongo. So that is why I'm saying that.
Thank you very much. Thank you very much, Wisdom. This helps very much. Wisdom is calling us from Sandema, and as he indicated, he's a surveyor. The surveyors will help you to be sure that the land is being talked about, this is exactly what it is. Because you can get something on paper and it doesn't exist on the ground. Thomas, you're calling us from Mamprobi. Hello, Thomas.
Something.
Hi.
Good afternoon.
Afternoon.
Again, something. My question is, if you are in the process in acquiring a land title, and Lands Commission has published it for 14 days, and has stated that if anybody wants to caveat, the person should provide court order, will, or letters of administration. And then the third part or the second part caveat without any of these documents, can Land Commission hold on your process, or Land Commission has to ignore them and then forward or complete your land title for you?
Okay, thank you very much, Thomas. My Lord will respond to that question. But before that, let me also take Latte. Latte, you are calling from, is it Teman?
Teman, yeah.
Okay.
I'm calling from Teman.
Yes, let's hear you, Latte.
Yeah, I want to ask my Lord a question about land. If a land is registered 200 years ago, maybe in 1903, and it's in the deed registry at Victoria Bank, can the land be resold by the Allodia owner who gave the land?
If the land was registered, you say, long ago, 200 years ago.
1903.
And then what happens?
Now, the children of those who sold the land are now trying to reclaim that very land their forefathers have sold. But we have the documents at the deed registry, and it's not in the land commission.
Okay. All right, thank you. We'll take a very last call. Tony, you're calling us from Teshi. Let's hear you.
Mr. Sampson, please, good afternoon.
Afternoon.
I acquired land at OEB, Valley View. Before I purchased the land, I did a search on the land. Because when I did a search on land, it was in the name of the family, it's a title land. So after the search, I go ahead and I paid the money to the one who was selling the land to me. I was on the site working when the police came. The police called me. He didn't come there. He called me for property fraud. That there's a gentleman who has come to report that the land that I'm working on it belongs to him. So I should stop work and come to the police headquarters. I stopped and I go to the police headquarters. Then he said, you have to find a day and come to the site because the guy also is complaining that the land is for him. We set it a date from January. We came to the site. They asked if we pay 1,500 each. I paid mine. He also paid. Since from January to June, the search is ready. When I go to the police headquarters property fraud, the CID tells me that the land on the search, it is in the favor, the title that is on the land is in the favor of my document. But he has realized that the guy who is complaining that the land belongs to him, the Busapeni who died some years back, sold the land to one company before the company was given to him. But meanwhile, the guy also is complaining that he has a title on the land. One particular land we are talking about, can we have two titles on one particular land? I think no.
All right. Thank you, Tony. My Lord, we'll start with Tony's predicament.
In respect of the caveat?
No, Tony is the very last call. Yes, he is the one that, got the land. The police called, and the two of them, there was a survey that had to be done around it. Everything has been done, and he says that it's in his favor, that it is for him. But it appears that previously it had been assigned, it had been given to somebody else.
Okay. Let me say that the law is clear that the police do not determine ownership of land. So if the matter went to the police station and one was determined owner, I would say that that is not proper. You have to go to court for the court to look at your respective interest to determine the one who is actually the owner of the land.
Great. We come to Thomas, who was talking about the one you intended to answer earlier. Thomas is the one who asked about the publication caveat and yeah.
Yes, the law permits. It's a process at the Lands Commission where you can caveat. Right. But where you are not comfortable, under Section 193, it talks about removal and variation of restriction on an application to the court by a person who has an interest in land. And on notice of the application to the land registrar, the court may order the removal or variation of a restriction. So in the course of the process, if you are not comfortable, you can go to court for the court to remove any restriction that has been put on your registration process.
Thank you. And the final one would be Latte. Latte says that this property must be like some 200 years old, and I was actually having a difficulty appreciating exactly the position he was trying to espouse. I don't know if you heard him better than I did.
What I heard was land registered about 200 years ago.
Right.
Can the owners come back? It depends on the type of interest that was registered.
Okay.
If it was, let's say, a lease that had been renewed, lease, the Allodia owner or the lessor has what we call reversionary interest. So the mere fact that the land was granted to you some time ago does not mean that forever the land is yours, if it was a lease. But if the land was granted as a freehold at the time, it was possible, then the grantor automatically divested his interest in the land. And the new owner, that's the grantee, becomes the owner, and the grantor cannot come back again.
Okay.
So it depends on the type of interest that was registered at the time.
Right. You had said something earlier, which is good education. I know friends who go ask for land for farming purposes, doing all sorts of things, pepper and the rest of them farming. You said that now by the law, you cannot get a land for the purpose of farming for more than how many years?
If it is for poultry, you can't get it more than 25 years. Or if it's for cultivation of cereals, you want to cultivate rice, maize, and you are acquiring land, it can be more than 25 years.
Okay.
Section 22.
All right.
And you can only do that where you have obtained the permission of the president.
Okay.
And I think I discussed in my book, I felt that this is unconstitutional because if you read the Constitution carefully, it places the president in charge of public lands.
Right.
The Constitution recognized individual rights. For example, under Article 18, the Constitution provides that an individual can acquire his property, and a group, including family, can also have their property. So, and the land, the family land, belongs to only members of the family. So if the family has a land and they want to grant it to somebody for 30 years, the law says you can't do that. You need the president's permission. When the president is only in charge of public lands, we have public lands, stool lands, and family lands.
Okay.
So the president is in charge of public lands.
That's right.
Stool lands are in charge of, stool occupants are in charge of stool lands.
Right.
And under Article 36(8) of the Constitution, the law holds the fiduciaries accountable.
Right.
So I think it's unconstitutional.
Okay. So as I told you last week, if you want to get more, here is the book, Essential Themes in Land Law and Customary Law by His Lordship Alexander Osei Tutu. He's told you something just a while ago, and never forget it. Many people think it is the police who determine who an owner of land is. That's not their job. They can try you to settle nicely, they can try and do things like that, but they don't make that determination. My Lord, once again, yes, and as we know now, it is on Amazon, so you can always access it. Those who are asking if it's on Amazon already, thank you so very much. We are grateful. Alexander Osei Tutu, His Lordship, is a Justice of the High Court in Ghana and in the Gambia. He's been our guest in 2 Sundays, helping us to appreciate land law. I hope you have been properly advised. I'm Samson Ladia Yanini. This is The Law. It's your legal light. It's your health law. Thank you.